Hey everybody, we're back in the shanty. I know I'm late again. I know it's not Tuesday afternoon. I'm really sorry. My only excuse is I've been very busy and I blame it all on you guys. So we got some news today and we're going to actually try to do this in under 10 minutes. But there's three things I want to talk about just to give you some update about what's going on and what's been going on in the world. We're going to start with the DOL's proposed regulations on raising the salary basis test. You all know about them. The DOL has taken the position that effective July, the salary level test is going to go up one notch, and then January of next year, it's going to go up another notch. July is coming quite quickly. And we were waiting for the lawsuit. The lawsuit has been filed. On May 22nd, a group of business people filed a lawsuit seeking to enjoin the order, seeking to overturn the proposed rule. And they're doing that by pointing out that this has already been litigated by a federal court in Texas, and that federal court in Texas, when it was dealing with the 2016 rule, has already said the DOL has well exceeded its authority. And this group of plaintiffs again says the DOL has well exceeded its authority by jumping the salary level test up as high as they've done it. It's beyond the DOL's authority to do that. And by including the automatic increase every 3 years without new rulemaking, which was basically the same arguments that they made on the 2016 rule. And basically what they're saying is, Judge, the Department of Labor has completely ignored your ruling. They say the following, quote, the department's 2024 overtime rule largely repeats the errors of the 2016 rule and fails to address the flaws previously identified by this court. So that lawsuit has been filed. The judge, we expect, will rule on a stay of the effective date of the rule. Don't forget, there's another lawsuit pending about the 2019 rule that is up at the Fifth Circuit. That lawsuit challenges the DOL's authority to issue any rule regarding a salary level test. They say that the statute doesn't provide for that. The statute only provides for a duties test. So we'll keep you posted on that. So the next thing that's happened is the EEOC has issued guidance on harassment in the workplace. It's been a number of years since the EEOC has issued any guidance on harassment in the workplace, 25 years, I think. And this guidance goes beyond the old guidance. It deals with harassment under any of the statutes that the EEOC enforces. So it's harassment not only based on sex, but based on race, color, religion, sex including pregnancy, childbirth, or related medical condition, sexual orientation and gender identity, national origin, disability, genetic information, and age over 40. Now, here's the first thing I want you to be aware of with regard to this guidance. Number one, it is not the law. Here's what the EEOC says about this in the guidance. The contents of this document do not have the force and effect of law, are not meant to bind the public in any way, and do not obviate the need for the EEOC and its staff to consider the facts of each case and applicable legal principles when exercising their enforcement discretion. So given that, why should we care about this? Well, here's why I think you should care. I think you should all go read this. And I'll tell you why you should go read it. It's long. I mean, it's like 160 pages, something like that. It's long. But it is chock full of examples of what the EEOC considers to be harassment. And it breaks the thing down in three ways. It says, look, we're going to talk about what the covered bases and causation are for harassment in the workplace. Was the harassing conduct based on the individual's legally protected characteristics? 2, discrimination with respect to term, condition, or privilege of employment. Did the harassing conduct constitute or result in discrimination with respect to a term or condition or privilege of employment? And 3, is there any basis for liability for holding the employer liable? So it's a really nice exercise for you in looking at what the EEOC considers to be harassing conduct and when there is liability on your part. And it's a nice guide for you to start to think about some of the things that are going on maybe in your workplace and whether or not they're going to cause you trouble. So again, this is not the law. It doesn't have the effect of law. It is guidance. And you should look at it in that regard. And the EEOC even says, this guidance serves as a resource for employers, employees, and practitioners. So it's for us. They're doing it for us. Isn't that nice of them? All right, so that's number 2. So what's the number 3? Well, the last thing I want to tell you about is something that you probably all have an interest in but didn't know you had an interest in. What we tend to do in our handbooks, in employee acknowledgments, and in a lot of employment contracts is we put in what we call a shortened statute of limitations. So that's the paragraph at the end of your job application that says, you promise if you're going to sue us, you'll do it within 180 days. Now, we do that based on some long-standing Michigan case law from the Court of Appeals that says a contractually shortened statute of limitations period is enforceable in the state of Michigan. It's not enforceable under the federal level, but it's enforceable under the state law, okay? And you can shorten, even if a statute of limitations is a year or 2 years or 3 years under a particular statute, that by contract you can shorten these statute of limitations. Well, the Michigan Supreme Court has agreed to hear a case involving that very issue, whether it is a violation of public policy to allow the shortened statute of limitations. Now, do you have to do anything about it? You don't. What you need to be aware of, especially if you're in the process of getting your handbook reviewed or a job application reviewed or something like that, and we're reviewing it, you're probably going to see a comment on that handbook that says, hey, this shortened statute of limitations is currently under review by the Michigan Supreme Court. We'll let you know what happens. Now, if you've got these things in your handbooks or your applications or your contracts, do you have to take them out? No, you don't. Not yet. Let's see what the court is going to do. But that's another thing that we're keeping an eye on. So that's what's going on in the world of employment law right now. 3 things for you to think about. That lawsuit based on the salary level test. Number 2, the EEOC's guidance. I really want you to go out there and read it. Go sit on the deck on the weekend. Pour yourself your adult beverage of choice and have some good, light, easy EEOC guidance reading. That's what I do. I don't know why you wouldn't do that too. And then number 3, if you've got a shortened statute of limitations on some of your employment documents, the Michigan Supreme Court is going to hear that case, and then we'll get some finality on whether or not that is legal. Hope everything's going well. Hope you're ready for a great summer. We'll see y'all next time.